They're fixing the chairs, you guys can chairs, but it's in location. Okay.
I'm sorry. Oh,
Just be careful.
this way. And speak to Norman. All right. So, ladies and gentlemen, those chairs have wheels on them, so be careful over there.
Oh, these?
Yes.
Yes.
Oh, my goodness.
Thank you.
So they're repairing the chairs that we have, and hopefully they will give us more comfortable ones.
Thank you.
Why they're all so close together because.
Too tired.
Oh, please be seated. We stand for you all. Oh. All right, everyone, please be seated. I'm glad everyone made it back and had their jury buddy. And I hope you all had a nice lunch, not too heavy because then people start falling asleep. So before I turn it over to the state, I want to tell you one more true story. In law school, you meet people, you become great friends with them. Throughout my college career and business school and undergrad, I would always meet great people. So one of my friends, she decided that she wanted to practice civil law. I've always loved criminal law. It's been my passion. So I'm like, yeah, I'm doing criminal law. So on the civil side, they don't have as many jury trials as we do on the criminal side. So she got called up for jury duty. And she's like, Stephanie, let's do lunch. So we did lunch. It was like no time had passed. We're talking about things that happened to us in law school, having a great time. And I asked her, I said, how is jury selection going? She tells me it's going fantastic. Now that I'm a judge, I'm like, how could it have been fantastic? You're not with me, right? So I said, what do you mean that it's going fantastic? And she's like, oh, I'm not going to be selected. She said, it's just like in law school. I'm on the back row. I'm keeping my head down. I'm not asking any questions. And so I started laughing and she was like, what's so funny? I'm like, I'm just so happy because we're going to be able to have lunch all week. She's like, what do you mean by that? I said, usually the people who are selected for juries are people who don't say anything. And I tell that true story to let you know that the state and the defense, this is the only time they get to speak with you. Outside of this, they're not going to be able to talk to you anymore, not even to say hello in the hallway. So they're trying to get to know you. It's not like they can go over to your house for dinner, get to know your friends and family. Each side just has 20 minutes to talk to you and get to know you. So other than raising your card saying, please place me on this jury, the other way to do it is just be silent. So with that, I'm going to turn it over to the state.
It's officially afternoon, so good afternoon, everyone. I'm loving the responses already. So my name is Megan Galloway. I represent the state of Texas along with Mr. Garahan, and I have a confession to make to you all. So I want you to think back to early this morning when you were on your way downtown to the courthouse, And it's no secret that there's a lot of construction going on downtown. Is that right?
Yes.
All right. And so I was in a hurry on my way to work this morning. And normally I am a very friendly driver. People that don't come downtown a lot don't know that there's a lot of lane closures and merging. And so usually I'm like, you know what? We're all friends. You can come on right in my lane. But this morning I was running a little behind and I was like, buddy, I'm sorry. I cannot let you merge today. And so I tell you all that story to say, if you see me and you say, hey, that is that jerk that didn't let me merge this morning, speak now or forever. Okay. So Judge Boyd did let you in on the best kept secret in the courthouse, and that is the people who stay silent are the ones that most likely end up on the jury. And so I know you probably feel like this. Please, please, please don't call on me. But if you don't speak, if I don't have volunteers, I'm gonna have to call on you anyway. And if you don't speak, you're gonna end up like this. It's called empaneled, and look at how happy those people look. So I want to talk to you all about the purpose of jury selection. What is the purpose? Well, like the judge told you earlier, we cannot talk about the facts that are specific to this case, but what we are going to talk about is the law that is applied in this case. And so the goals are to learn about you and your views and any biases or feelings that you have towards those laws. Both the state and the defense are just looking for 12 people that can be fair and impartial and are the right jurors for this specific case, okay? So who can tell me who that is? Number 4, who is that?
Really?
It's Willie Nelson. And what does Willie Nelson love?
Music.
Nelson most known
We
for.
don't judge people.
Number 21. What does Willie Nelson love the most?
What he loves them?
Yeah.
What he's doing there?
And what is that?
What is that? He's smoking weed.
He's smoking weed and
He's known for
marijuana.
that.
Right, yes. And so Willie Nelson is very outspoken about, his love for marijuana and weed, and that's all fine and dandy. But the reason that I bring this up is because he has a fundamental disagreement with the law against marijuana, okay? And so I'm going to tell you something of what I call the Willie rule, and I'll refer to it later on. And that is 1, do you understand the law? 2, do you disagree with the law? And 3, can you follow the law? Does everyone get that?
Yes.
Yes. So Willie Nelson probably would not be a good juror on a marijuana case because he fundamentally disagrees with the prosecution of marijuana. Does that all make sense to everyone?
Yes.
Okay. So like I said, fair and impartial, all that means is that you're going to follow the law that the court gives you and base your decision on the evidence that is presented in the case. So I have a rule in my jury selection. I call it no waffling. And what does that mean? So like the judge said, we are in court almost every week. I a lot of times get jurors that I ask a question and they kind of are like the little engine that could, right? And they're like, I think I can. And unfortunately, in this courtroom, I think I can is not good enough, okay? So I want you all to listen to the questions that I'm asking, answer with yes or no's, and just listen. And if it's not a yes or no, just which one you most identify with, okay? Does anyone have any questions so far? Okay, so the burden of proof in a criminal case rests solely upon the state. It is beyond a reasonable doubt. The judge did tell you that, but what does that mean? Like the judge said, there is no definition for that. But I will, illustrate for you how I like to think of it. It's not beyond all doubt. It's not beyond all unreasonable doubt, not beyond a shadow of a doubt. And it doesn't mean that you're 100% sure. It goes to the elements of the offense. And does anyone know what you would be called if you were 100% sure of what happened?
That's a good one.
Liar,
What was that?
liar,
Juror number 4?
sorry, yes,
You said a liar?
liar.
Okay. Does anybody else have any answers?
A witness, the defendant.
What was your card?
Oh, I'm sorry.
74.
Defendant?
The defendant, you said? Okay. And what was you?
19.
19. What was your answer?
A witness.
A witness, right? An eyewitness. that was there, that observed what happened, and that is, is gonna come into court and testify to what they saw. Now, has anyone ever come home to this? Let me see a show of hands. Okay. And so juror number 17, can you tell me what happened here?
Well, I think I can. I think this lovely little animal done.
Right, and so you said, I think I can't do it. And so right now, right, you don't know, anything, right? I just showed you a picture. So let's take a look at the case study of the state versus puppers. Okay, so you will learn testimony is evidence. And what that means is the evidence that you are going to hear is going to come from this witness stand where Eli is sitting. There's going to be witnesses that are going to be testifying. And so in State v. Puppers, let's say we're going to call Puppers' owner, Maria. And she's going to testify. Me and Puppers were the only ones that were in the house. And I was upstairs the whole time. I was never by the trash can. Then let's say we call Maria's neighbor, George. And George is going to say, well, I was looking through my side window and I saw Puppers, jumping around a lot in the area where the trash can is. And then we can also put in like photos, evidence like this, where it shows Puppers near the trash, right? If there's no other evidence, we're going to think of what is possible versus what is reasonable, right? Is it possible that somebody broke into the home and no one saw? There's no other fingerprints, nothing is taken from the home. Anything is possible, right? But what does the evidence suggest? Okay. Does everybody understand that? Yes. Does anybody have any questions? Okay. Moving on. Okay. So knowing that the standard is beyond a reasonable doubt, is there anyone that says that the state should be held to a higher standard and require 100% proof of the offense? Anyone that believes the state should be held to a higher burden? What is your number? 5. And so you think beyond a reasonable doubt is not high enough, the state needs to be held to a higher burden than that. So,
Okay, I'm sorry, if you could make sure you speak up.
Oh, I just want to make sure that I'm putting more weight on your word. Definitely. Held at a higher standard and required, yes.
Okay, so you believe we should be held to a higher burden.
Sure.
Okay, thank you. Now I have a question I want everyone to respond to. I'm going to read it out and then I'm going to ask you to raise your card with the number that you most identify with. So the question is, what is your opinion of the criminal justice system? The first is choice 1, you think it's terrible, it takes away our rights. 2, you think it's concerning and that it interferes with our rights. 3, you think that it's helpful and looks out for citizens. Or 4, you think it's beneficial and protects us from the harmful actions of others. So who here most identifies with choice number 1? Please raise your card. Juror number 40. Okay. Choice number 2, who most identifies with that? Jurors 4, 5, 6, 8, 9, 19, 20, 26, 34, 38, 39, 45, 48, 43, 50, 51, 57, 58, 63, 69, 73, and 74. Okay, and once I call your card, you can put it down. And then, sir, go ahead. What is your number?
51.
Okay, thank you.
Number 2. You mentioned the what most aligns with our thoughts.
Yes.
I guess the question would be what we
I'm sorry, who's speaking?
early or what we think it should
Can you
be.
stand up, please?
I guess my question is like, should we think about what we think of the government currently or what we think it should?
What your current viewpoint is of it right now. Number 2? Okay, thank you. And then I'm gonna skip just for time purposes. Who is number 4? You believe that it's beneficial and protects from the harmful actions of others. Okay, juror number 7, 11, 12, 21, 30, 32, 36, 37, 64, 70, and 30. Now the judge we have in this case what's called a multi-count indictment, and that's just what the judge was talking about. There's 2 different charges. It's the same act, all that means is that it just fits two different parts of the penal code, okay? So it doesn't indicate anything, it's all the same act. And so we're gonna talk about the elements of the offense. So the first counts 1 and 2 are aggravated assault against a public servant. And so the elements are on or about the offense date in Bexar County, Texas, the defendant did intentionally or knowingly threaten imminent bodily injury to the victim and did use and exhibit a deadly weapon that in the manner of its use and intended use is capable of causing death or serious bodily injury. And the defendant knew that the victim was a public servant lawfully discharging an official duty. That's a lot of legal mumbo jumbo. We'll talk about it in detail in a little bit later. Count 3 is deadly conduct, which is on or about the offense date in Bexar County, Texas. The defendant did knowingly discharge a firearm at or in the direction of one or more individuals or a vehicle and was reckless as to whether the vehicle was occupied. Now let's talk about the mental state. Intentionally is legally defined as the defendant's conscious objective or desire to engage in the conduct. So what I think about when I think about that is, did the defendant mean to do what he did? Knowingly is defined as the defendant is aware of the nature of his conduct or the circumstances that exist. So when I think about that, I think about, did you know what you were doing when you did that? And then recklessly is a conscious disregard of a substantial and unjustifiable risk. So what I think about that is, did you know that there was a big risk that could happen when you did it and you did it anyway? So the law states that regarding the mental state, you are not required to be a mind reader. You can infer the mental state from words, actions, and circumstances. So what does that look like? Well, we are going to explore that with the hit movie Titanic, which is my favorite movie. Okay, so there are 3 characters at play. 1 is Cal Hockley, 2 is Rose DeWitt Bucator, and 3 is Jack Dawson. And so let's look at the circumstances and determine what is Cal's intent. Cal grabs a firearm from his personal attendant. Cal starts shooting at or in the direction of Jack and Rose. And there are many other people in the area, and Cal chases Jack and Rose without regard for any of the innocent bystanders, and he continues shooting at them until the magazine runs out of bullets. Now, what do you all think Cal meant to do? I'm gonna pick on somebody. Juror number 15. What do you think that Cal meant to do? Hit Jack or Rose? Okay. And juror number, are you 14? Okay. Did Cal know what he was doing when he did that? Do you think? Yeah. Yes. And what risk did Cal disregard? I'm gonna call on you. What's your number?
Killing them.
Yes, right. And all the other bystanders that were in the area as well, right? So Rose and Jack did not get hit. Is this still an aggravated assault with a deadly weapon?
Yes.
Yes, right? Because aggravated assault with a deadly weapon is the threat of imminent bodily injury, plus the use and exhibition of a deadly weapon. So everyone's clear on that? Okay. So imminent just means like near at hand or impending, and bodily injury is just anything that could cause you physical pain. So like I said, the complainant or the victim does not have to actually sustain bodily injury for the offense to be completed. Does anybody disagree with this law? No. And the defendant does not actually need to intend death or serious bodily injury. Does anybody disagree with that portion of the law? Now, let's talk about what a deadly weapon is. Per se, right, a firearm is legally a deadly weapon, but a deadly weapon can be anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. So regarding firearms specifically, even though legally it is one, we all know that firearms can cause serious damage or death to someone, right? Now let's talk about what a public servant is. That is a person that is employed or otherwise designated as an officer, employee, or agent of the government. And so what does that look like? That could be a judge, a prosecutor, any elected officials, peace officers, correctional officers, and jailers. Okay. And so acting under the color of employment, all that means is that they are acting in an official capacity and doing their duty. So does anyone have any ideas of how you can tell if an officer is acting in his official capacity? I'm gonna pick on you. What is your number? Your number 20. Okay.
Oh, and
And
I'm
I'm gonna
sorry,
remind you to keep your
counsel, if I could have defense and state approach, please.
juror number 20. Do you have any idea of how you can tell that someone is acting in an official capacity?
Like police officer,
Like a police officer, yeah.
whenever they get a call for like a disturbance or something.
So, how about juror number 16? Do you have a different answer?
So say if they've identified themselves and they're engaging in alcohol interaction.
Okay, yeah, those are very great answers. Right, and so some examples that I've had up here, right, is in addition to what jurors number 20 and 16 said, right, they're usually going to be in their uniform most times, right? They're going to have their badge, their radio. Sometimes they can be in their patrol vehicle, and then with the patrol vehicle specifically, if they're not in a like unmarked capacity, they would be in a marked motor vehicle that has decals letting the public know, hey, I am a police officer with the Bexar County Constable Office. Does that seem pretty straightforward to everyone?
Yes.
Okay, so I have this question and everyone has to answer. And so what it says is, I don't believe our judicial system should be prosecuting individuals for aggravated assault against a public servant. So who agrees with that and says, hey, public servants, it comes with the job and the state should not be prosecuting those cases? Does anybody feel that way? No, so everyone disagrees and says that it's a issue that should be addressed there. Now, I want to ask you all about your opinion of law enforcement in Bexar County. 4 is going to be, you have a very favorable view of law enforcement in Bexar County, and 1 is going to be, you have a not good view of law enforcement, okay? And then 2 is just a step above that, and 3 is just a step below very favorable. Does everyone get that? Okay, so I'm gonna start with the 1s. Who has a very low opinion of law enforcement in Bexar County? Juror number 4. Anybody else? Okay, how about with choice number 2? So that's 5, 6, 19, 20, 29, 40, 44, 45, 47, 51, 52, 53, 43, 57, 59, 63, 68, 69, and 72. Okay, I'm sorry. So y'all that just answered for choice number 2, please raise your cards again. And so I'm going to ask you, if you were selected as a juror to sit on this case, would you be able to disregard your negative view of law enforcement and set it to the side and render a fair and impartial verdict in this case? Would you be able to set aside your low view of law enforcement in this case? Juror number 6, same question. You would not. Juror number 19, would you be able to set aside your view of law enforcement?
Yes.
Juror number 20?
Yes.
Juror number 29? You got to say yes.
Yes.
Okay. Juror number 45?
No.
Juror number 46? Would you be able to set aside your negative view of law enforcement in this case?
Yes.
47,
No.
51,
Yes.
52, 53, 57. Would you be able to set it aside? 59,
Yes.
63.
I'm sorry, I can't hear. If y'all could stand when you're asked the question so the court reporter can hear.
Okay, so I can't, get into the circumstances as we've stated. So are you able to disregard your opinion, your negative view of law enforcement, and render a fair and impartial verdict? So what that looks like is listening to the evidence, having an open mind, and not letting your negative view influence your view of the evidence or your verdict in the case?
Yes.
68.
Yes.
43.
No.
Thank you. Okay, so now I want to ask you all about negative interactions that you've had with law enforcement officers. Is there anyone here that says, I have had such a negative interaction with police officers that I am just unable to trust police officers? If that's you, please raise your card. Juror number 4, juror number 34, juror number 40, 45, 57, and 63. So I'm gonna ask y'all to keep your cards raised again.
5 minutes.
Juror number 4, would you be able to disregard that?
No.
Juror number 34, would you be able to disregard that?
Yes.
Is it gonna be weighing in the back of your mind?
Yes.
Okay, so you're not gonna be able to disregard it.
But I'm trying.
Okay,
All right,
no
so
problem.
everyone, this is what I need everyone to do. You have to stand if you're not on any of those rows because the court reporter cannot hear you. And keep your voice at this level because otherwise everyone can't hear you. I need to be able to hear you. The other jurors need to be able to hear you because your answers are very important. All right, you may continue. And I paused your time.
What's your number again? 34? 34. Okay, so you're hesitating and just answering the yes that you're trying to. Are you going to be able to disregard that negative interaction, or is it going to be in the back of your head like, I had that negative interaction, I'm going to view the evidence in the lens of my interaction?
It's gonna weigh very heavy, so it's probably gonna go down.
So you can't disregard it. Okay, thank you. We can have a seat. Sir, can you please stand up, number 40? Can you disregard it?
Remembered it for 40 years. I don't think I'll.
Okay, so it's fair to say that it would weigh in your decision making in the case, correct? Yes.
Yes.
Okay, thank you. You can have a seat. 45, please stand up. Okay, would you be able to disregard it or would it weigh on your decision making in the case?
Wouldn't be able to get through.
Thank you. 57, same question.
No, I would be able to disregard.
Thank you. 63.
Yeah.
Thank you. We've kind of talked about this, right? Testimony and evidence. You'll see evidence in this case. I'm going to skip forward. Like the judge said, there are 2 phases in the case. There is the guilt innocence phase. That is when you're looking at whether or not the defendant committed the acts for which he's charged in the indictment. The punishment phase, you're able to look at a whole bunch of different things. And so the judge went over the range of punishment with you. You all said you can keep an open mind and consider the minimum and the maximum. And so let's talk about sentencing. What do you all think the main purpose of sentencing for crimes involving firearms is? Do you think it should be punishment? Like if you do the crime, you do the time? Do you think it should be deterrence, preventing this or these acts from happening again? Do you think it should be making amends, helping the victim recover, or do you think it should be rehabilitation that everybody messes up and can change? So if you say punishment, would you please raise your card? Jurors number 1, 5, 7, 10, 11, 12, 13, 14, 15 through 17, 19 through 21, 23, 25 through 29, 30 through 33, 35 through 41, 44 through 50, 52 through 56, 57, 58, 67, 71, and 73. And then if you most align with rehabilitation, would you please raise your card? So those are 42, 43, 45, 59, 62, 63, 64, 65, 68, and 74. Judge, how much time do I have?
1 minute and 21 seconds.
So I just have one last question. Is there anyone here that has had a family member or somebody they know or love that has been convicted of a felony or went through the criminal justice process and they feel that they didn't get a fair shake and you just wouldn't be able to disregard? Please raise your card. There's 5, 15, 30, thank you, ma'am, and 74. Okay, and is there anyone here that just for religious, moral, personal reasons just feels that they cannot sit in judgment of another person? 37 and 5. Okay, and 32, 33, 37, and 40. At that time,
Yes.
thank you all.
For the clicker. If you give me a second, ladies and gentlemen, the cords weren't working over here. I had everything set up. Sure.
Wait, just a minute.
There we go. Okay. Everything, Judge?
Yes.
Thank you. Please, the clerk. Good afternoon, ladies and gentlemen. I know that the prosecutor said it was the afternoon, and I get to go even later in the afternoon when everybody's a little bit more ready to get out of here. But if I could still have your time and attention, it's going to be vital to this case. And I want to say that obviously, as everybody has said, this is the only time we can talk. And this is going to be a judgment-free zone. Let me explain. So I do not care what your answer is. I'm not looking for any certain answer. It can be anything. I don't think I've ever had a jury selection where everybody agreed they couldn't hold it against the defendant if they couldn't testify. So I have a feeling that there's some people that wanted to raise their cards on that just didn't. But it's very vital that if you have a thought, that I know now. Because when we get over here and there's 12 of you that are going to be selected and sitting here, you're actually going to take an oath and swear to make your decision based on the facts and the law. And if you can't follow the law and you're over here, well, that just means now Tyler doesn't get a fair trial. And our system doesn't work if we can't get a fair trial. And so there was some other things about, could everybody be fair and impartial in this case and not a single person raise their card? I have my doubts about that as well, because even in DWI cases, there's people that misdemeanor DWI cases, there's people that can't be fair and impartial. So especially on an allegation like this, which is a first-degree felony, I'm sure there's some of you that maybe had hesitations about raising your card. And I just ask that there's no right or wrong answer. I'm not going to judge you. Nobody's going to judge you here. We're just asking. And so I'm going to go through a few other potential witnesses that I think may be called at trial. And if you could also just raise your card if you recognize any of these names. So we already went over Tyler Ashbaugh. Nobody knows my client, correct? Okay. We have a couple San Antonio Police Department officers, Philip Jaimez, Roland Acuna, Chad Tudor, and then this individual is not with San Antonio Police Department, but Harold Clements. Does anybody know any of those individuals personally? Number 59, who do you know?
I wouldn't say I know them by name, but I see a lot of law enforcement every day. I work at safety headquarters quite a bit.
Okay, but you can't put a face to any of these names?
No, but once I see them.
Okay. And then number 70, are you the gentleman that's with San Antonio Police Department? Yes, okay. So you recognize those three officers?
Not, like I can't put a face to them, but I can't put a face to the name.
Do any of the names?
Yeah, and I'm also park police officer.
Park police officer. And let me ask you, as a police officer, would you be able to be fair and impartial in this case, or would you have the instinct to want to protect officers so much that it might interfere with your decision making in this case? Would you feel that pressure? You're leaving fair. I appreciate that. Thank you. Okay. Has anybody, and sorry, I'm speaking the other way. Has anyone attended Calvary Temple Assembly of God Church on O'Connor Road? Now, that sounds like a weird question, but has anybody attended that church or is a member of that church?
Like attended it once?
Even once?
Yes.
Okay. Without saying any of the specifics, if you know, have you heard about this case?
No, I went there like 1998.
Okay, so, okay, I appreciate that. Okay, so now we're gonna talk about human perception of events. Can your initial perceptions about a situation or a person be wrong? Okay. Now, I know that Ms. Galloway talked about eyewitness testimony and that being a possible way that you might know 100% certain. But can eyewitness testimony be wrong?
Yeah.
Yes.
Okay. Sir, number 70, have you conducted any investigations where you've talked to different witnesses or at least talked to different witnesses when you were looking into a crime?
Yes.
Okay. And have there been instances where you've talked to two witnesses that say different things?
Yes.
Okay. So that would mean that somebody has not perceived the incident correctly, correct? Okay. And so you would agree that some people can see the same observation but come to different conclusions. Okay. Now, I think everybody's going to remember this. Okay. Who sees this as a gold and white dress? I don't know how that's possible, but it still gets to me. Yeah, people see that, people will swear to you that this is white and gold, and then the rest of us will swear that this is black and blue. And we see this. I'm giving you all the time you need to look at this, and we're still seeing two different things. Okay.
You see black and
Okay. And I want to be clear on this. This is not a
Wow.
this is not a legal, this is not a law, but this is an idea. It's called Hanlon's razor. And the idea behind it is to never attribute to malice that which is adequately explained by stupidity. And so in this picture, what we see, and a lot of you probably can't read that, but it says, this person on the other side of the door is saying, is this a mean door blocker or is this a silly door person? Now that would be me. I would be the silly door person because I'm always thinking about different things, cases, and I don't read the door. I pull it when I should be pushing, push when I should be pulling. And you can see that the person attempting to either open the door or hold the door shut has furrowed brows. Maybe they're trying to try harder because it's not working. And so this person is saying, this person could legitimately think, well, this person's just trying to hold me out. When in reality, there could be a different possible explanation of this person just kind of getting it wrong. Does anybody have an example that they could share where somebody thought somebody was doing something intentional to you, but it turned out it was just a miscommunication or misperception? Or vice versa, where somebody thought you were doing something against them and it was a totally innocent occurrence. Does anybody have any examples of that? I know we all come from families and surely this happens. 56, can you explain that?
Like for me, but like my job, we get it all the time. I'm a 911 dispatcher, so people call all the time wanting to say someone's doing something wrong that they're not, and then when we go out there, they're completely just minding their business, doing whatever. So it's the perception that people have of other people.
So they think this person looks like they're doing something wrong, but that person was just
Correct.
wasn't doing anything wrong. Okay, that's a good example. I appreciate that. Okay, and another example, something like this that a friend told me, was they had a teenage son and he was outside and it was really muddy and he was walking back into the house. And the dad's like, come on, man, you got to take your shoes off when you come inside. And so what he does is he goes over here to the couch, puts his foot up and unties his shoes to take it off. And so his dad thinks he's being just kind of a jerk about it, like you're trying to mock me now. Well, the son's just not thinking at all. He's like, well, this is what I do to take my shoe off, and just doesn't think about it. Okay, here's just another little example here, and I know it's a little bit small, but it says, and it's what I explained earlier, but this person thinks over here on the left that somebody's littering, and this person on the right is dragging a trash bag, and We have litter falling out, so they were actually trying to do the right thing, carrying that trash bag, but it was falling out, and this person thinks, well, somebody must be littering in my neighborhood. That's just another example of that. Okay, something else that I'd like to discuss with you is that your verdict is going to be limited to the indictment. It's going to be limited to those 3 counts that the judge and Ms. Galloway explained to you. 2 counts of aggravated assault on a public servant, 1 count of deadly conduct with a firearm. You're not deciding if Tyler has done anything you don't like. You're not deciding if you like Tyler. You're not even deciding if he's done something else illegal. You're only deciding based on those 3 things if every single element has been met beyond a reasonable doubt. And so, is there anybody who believes that they might convict just because he did something else that was wrong on this? And it's okay if you do. 32? You believe if he just does something that you just find really bad, you would convict on these just to punish or send a message?
I believe based on what we've already been told and having family that has been police officers that were assaulted, I do believe that I would not be advised.
All right, so you're whispering. The court reporter can't hear.
Having family that has been in the police force that has been assaulted, I do believe based off of that and what we've been told that I would find it very hard to not already hold some sort of resentment towards Tyler.
I understand. And so would you, in this case, is it fair to say that you could not be fair and impartial?
I do believe so.
Okay, appreciate that. And your card number, sir, was
32.
32. And 38, if you could stand up. Would you, if he did something else, 48. If he did something else, if you believe he did something else, but you had reasonable doubts about those charges, you still might find him guilty just to punish.
I think based on the charges that we've seen, there's sometimes people can be foolish with a deadly weapon. And I think it's just as dangerous as intentional assault. So I think that's where it's kind of hard to be completely non-biased whenever it's still something that threatens lives and things of that sort.
Okay, so would you not be able to be fair and impartial in this case?
I don't think so, no.
It has to be a yes or a no.
No.
You could not be fair in this case.
No.
Thank you, appreciate it. All right. I'll get to you in a second. Number 49, yes, ma'am.
Yeah, I think I would have some bias just because I've had people that I know in the SAP that have died because of
Sorry.
gun violence or whatever. So I don't think I'd be able to.
Okay. You don't think, or you would not?
I
you
would
could,
not be.
You would not be fair in this case.
And I have family members that are.
Okay, so just something you could not be fair in this case.
I don't think, no.
You could not think. 49 and 74.
74, yeah.
Could
I
you-
get kind of genuine having family members in the police force, also having strong opinions about guns and access to them. I'm concerned. I don't think I can. I know I can't be partial.
You know you couldn't be. Thank you. And raise your card 57. Come stand up.
I don't think I could be partial because this through the conversation that this took place on a church property. And knowing that there could have been other people besides the ones who defend themselves.
Well, so nobody has said that yet. Have you heard something in the media?
No,
or-
just because you asked if
Okay.
they attended that particular church. So just knowing that part, I don't know that I could be impartial.
You don't know, or you could not be? I think we kind of need a yes or no.
Yeah.
You could not be? Okay, thank you. Okay, I think, and yes, ma'am. Number 12.
I don't think I could be partial either.
Okay, so you could not be, or you don't think?
I could not.
You could not be partial, fair and impartial. Okay, I appreciate that. Thanks for reading this. Okay, anybody else before I move on? Okay, and so here's another hypothetical to get you thinking about it. Let's say this is a DWI trial. And let's say I have a different client, because I don't want you to be thinking this about Tyler. But let's say I have a different client, it's a DWI trial, and the guy's just being a jerk to the cops. He's cussing him out, he's arrogant, you don't like him. But then you look at the evidence and, he does really good on the tests. He doesn't sound drunk. You really don't have any signs of intoxication. And the only thing you're there charged with is driving while intoxicated. And this guy's a real piece of work and you don't like him at all. Is there anybody that would convict in that situation just because you don't like the defendant and he needs to learn a message? Number 59, you would convict in that situation?
It's a pretty hypothetical. I don't believe anybody's drink and drive. I'd put the hammer down on anybody drinking and drive.
Okay.
Riding a horse different, you know, but.
Yeah, I got you. Okay, and so I need to take that even a step further with this, because remember I said, even if this person has done something different that is illegal, you're only to limit your verdict on these charges. So let's say in this case, it's a DWI, and you also don't like the guy, and he actually shoves the cop too. But but they're only charging him with DWI. Maybe that was taken care of some other way, but they're only charging him with DWI. And you can agree you have reasonable doubts whether he was intoxicated, but he pushed the officer, which is illegal, and he assaulted the officer. Is there anybody that would convict in a situation where you think Tyler did something illegal, but it wasn't this?
Yes. All right, ladies and gentlemen. The state is in charge of presenting indictments to a grand jury. Does everyone understand?
Yes.
So if you have a case, and let's say that someone is charged with theft, stealing, but for the penal code, they call it a theft. But really what it is stealing. Is everyone following my hypothetical?
Yeah.
So if someone is charged with theft and they say, you know what, I want to go to trial on that case because I didn't commit a theft. And they decide to go to trial, maybe because they say I didn't commit a theft, or they may be thinking because the state can't prove that I committed a theft. So that person comes to trial and that person's like, okay, I'm ready. My attorney is prepared because I'm going to trial on a theft. Does everyone understand my hypothetical? All right. So let's say that person goes to trial. Their attorney is asking questions because this is a theft case. And then you're listening to the evidence as a juror, maybe, and you discover, yeah, the state is going on a theft case, but really, from what I know, this person graffitied a building. They wrote messages on a building, and you're not allowed to do graffiti. I think everybody knows graffiti is against the law. So that person is sitting on trial for a theft case. And maybe information comes out that, hey, they grabbed the person's, they committed a theft. And after committing the theft, or either before committing the theft, somebody says, oh yeah, I recognize that guy because that guy was spray painting a wall. And then I saw him commit this theft, or I saw her commit this theft. The person who's on trial is like, okay. In their mind, maybe they're thinking, I committed a graffiti, but they're not charging with me with graffiti. I'm only going on a theft. Does everyone understand the hypothetical?
Yes.
So the question becomes, in that case, the state has to prove up a theft. The defense knows that their client is here for a theft case. Maybe you're sitting on the jury and you hear about some graffiti case. You hear that maybe somebody was marking a wall before they committed the theft. The question becomes, that person is only here for a theft, and the evidence that you're hearing is related to that theft, and that's the only thing that they're charged with. Is there anyone here who's going to say, you know what? The state only charged this person. They're only coming here for a theft. That's what we're supposed to be here on trial for, but I really don't like people who commit graffiti. So you know what? Even though the state didn't prove this theft case, we know that a witness testified that they graffitied a wall before committing the theft. So even though we're not going to find them guilty of the theft, or even though the state didn't present enough evidence for a theft case, I'm just going to find him guilty of theft anyway because I don't like graffiti. Does everyone understand the hypothetical?
Yes.
So what parties want to know is sometimes you may not like somebody, right?
Yes.
In criminal cases, it's not really about whether you like somebody or not. It's about this is what they're charged with. This is what you have to decide based upon the evidence that you received. Does everyone understand?
Yes.
So is there anyone here, if someone, anyone, in this case, I think the defense question is, if the state has filed an indictment or sought an indictment, and these are the three charges, and you know that you're here for the charge of aggravated assault on a peace officer in deadly conduct, those would be the only three counts that you would be expected to reach a decision if you can. If you dislike a person, are you going to hold it against them? Is there anyone here, if for some reason you don't like the person who's accused, are you going to say, I don't like that person, state didn't prove their case, I don't care, I don't like that person, so I'm finding them guilty? Is there anyone here who's going to do that? Raise your card. Is there anyone here who says, okay, the state has brought, or he's been indicted for these three charges? Count one, count two, count three. Oh, by the way, evidence has been brought out where somebody committed a graffiti. The state didn't prove these three charges beyond the reasonable doubt, but I don't like graffiti, so I'm going to find him guilty of the charges that the state didn't prove. Is there anyone here who would do that? And if that is you, that is fine. There's no right or wrong answer. Both parties just want your answer. So the ultimate question is there anyone here who is not able to listen to whatever evidence is brought to you? If you can't listen to evidence, raise your hand. Is there anyone here who is going to find somebody guilty of something that they have not been charged with? Raise your hand. All right, defense, you may continue.
Thank you, Judge. If I could I have that time?
Yes. Oh, I paused it.
Okay.
Yeah.
And
You have 10 minutes and 40 seconds.
And so the judge touched on this, and I think it bears repeating. So the burden in this case is beyond a reasonable doubt. It's the highest standard of any court, civil, criminal. It's the highest standard. And so let's assume, and I know this isn't going to be an imperfect example, but this is, you have no evidence right here. It's just so that everybody can see. And then all the way over here to my chair is 100%. So there's different legal standards. So reasonable suspicion, for instance, probably somewhere around here. That's what an officer needs in order to detain somebody, in order to actually say, hey, stop there, put your hands behind your back. I'm going to put you in handcuffs just to investigate this offense. You're not under arrest. It's just reasonable suspicion. Then we move up to probable cause, which is, that's the standard to make an arrest. And then we have clear and convincing evidence. And we also have below clear and convincing, we have a preponderance of the evidence, which the judge was stating. Cases involving money, cases at the civil courthouse are decided by preponderance of the evidence. Where does the scales of justice, do they tip towards one side or the other? And you just decide one of those that makes more sense and you believe that burden's met. So who here on the front row has children? Okay, juror number 2. How much evidence would you want before the state of Texas could terminate your parental rights? A lot, right? Right? And that's clear and convincing. What we have here is beyond a reasonable doubt. That's even higher than that. So if you think that this case is clear and convincing, but you have even one doubt about any element, and that doubt is reasonable, the law says you have to find the defendant not guilty. Is there anybody who wouldn't abide by that standard and would require less evidence to convict than beyond a reasonable doubt? Yes, sir. Number 32, if you could stand up.
It reiterates back to kind of what I had said previously. It's just kind of more of that, knowing just the circumstances alone,
Okay,
I feel.
yes, sir. And you previously said you could not be fair in this case, correct? Okay, I appreciate it. Anybody else? Okay. So, as I stated, it's not the size of the doubt, only if the doubt is reasonable. And here's an illustration to describe that. So who remembers before we had these? Okay, could you explain that? Do you remember why we have these?
Because somebody put laced some of the Tylenol with poison and people died because there wasn't a safety on it. We were trusty. I mean, we trusted everybody, and unfortunately, we can.
Right. So for anybody that can't see, this is the safety seal on the pill bottles that you actually have to rip open. Before that, these didn't exist. You just open it up.
Yeah.
And juror number 21 stated that there was an instance where people were actually being poisoned. They were putting cyanide pills in Tylenol bottles, and people died because of it. Now, let's imagine that that is happening right now. Our pill bottles are open. You've heard reports on the news about people dying, and then your child has a headache, and I don't have it, and you're saying I don't have any Tylenol at home. I got to go to the store to go get it. Would you go to the store and get Tylenol?
No.
Okay. So you see, out of all the pill bottles in all the United States, the chance is probably pretty low. But I think everybody here can agree that her hesitation and her doubt is reasonable. Nobody's going to say, as a mom, that's unreasonable what you did. You should have just gone out and bought the pills.
I remember.
Right?
I had little kids at that time.
Okay. They're probably pretty scary at that time then.
It was.
Okay. And so, once again, not the size of the doubt that matters, it's whether that doubt is reasonable. Okay, and then here's, if everybody could just decide on a question, on a number, I'm going to read you a statement. And the statement is, and you're going to say whether you strongly agree or strongly disagree. Strongly disagree is going to be, your number is going to be 0. Strongly agree, your number is going to be 10. If you're neutral and you can see it both ways, you're a 5. But if you lean more towards agree, you can be 6, 7, 8, 9. If you lean more towards disagree, you could be 1, 2, 3, 4. But everybody just needs to pick one number. We're not going to be doing any explanations, so perfect if you don't want to explain it. You just pick a number and we'll let you know. So once again, it is better to let 5 probably guilty people go free than to convict 1 innocent person. So 10 you agree, 0 you strongly disagree. Okay, juror number 1.
It's a tough one.
First one that pops in your head, doesn't matter. 3, okay. Number 2. I'm sorry? 0, okay. 3. 6.
10.
10. 0. And does everybody understand this? So 0 is saying it's better to convict 1 innocent person than let 5 probably guilty people go free.
Then 10.
Okay. Okay.
Sorry, we were backwards.
Okay. Let me do it one more time. Okay. The statement is, are you deciding if you agree with this statement or disagree? It is better to let 5 probably guilty people go free than to convict 1 innocent person.
5 minutes.
If you agree with that, you are somewhere a 10 or somewhere in that range. Does that make sense to everybody now? Okay.
I would go with 9.
With 9. Okay. 2.
6.
10.
And if everybody could say it loud. 3. I'm sorry.
6.
10.
8.
8. 10. 9.
10.
Okay. Now let's do it when I point at you. I don't want us going too fast. Okay.
5. 10.
7.
4.
Let me make sure I get this right. 22 is over here.
8.
6.
10. 9.
10.
9. 9.
Okay. Is that 30 back there, ma'am?
9. 2.
6. 7.
7.
5.
6.
8.
5.
8.
7.
8.
10.
5.
5. 5.
5,
Like,
10.
5.
Eight.
We gotta start over here, sorry.
5. Yeah, after that. 9.
Out of 7 to 8.
4.
Okay, that's this, I'm not gonna harp on that, okay. Has anyone seen any news reporting regarding this case? Anybody here? Okay, and without telling me anything that you saw, what number are you, ma'am? 34. 34? Are you the only person that's seen any news reporting on this case? Okay, and the judge is gonna instruct you, I assume, to not, for everybody that makes it on the jury, to not look it up, so I don't want anybody going and forming opinions already, so 34. You've already read something. Are you going to now put a burden on the defense to disprove what you've already heard?
I didn't read it. It was on the news. But
Okay.
no.
Okay. Could you still be fair and impartial in this case? Based on what you've heard?
Yes, to that.
Okay. Have you formed any opinions as to Tyler's guilt?
No.
Okay. Thank you. Has anybody else seen any media reporting regarding this case? Okay. Nobody. Okay. Does anybody enjoy following updates on high-profile criminal cases? Okay. And, okay, let's get those numbers. 5, 6, 11, 12, 13, 15, 16, 19, 31, 35, 37, 41, 48, 49, 51, 55, 56, 57, 58, 67, 71, 73, 70. Judge already went over this.
50 seconds.
50 seconds, all right. Knowing just these charges, is there anybody else, and I know this has been asked, but I just want to make sure, is there anybody else that just based on the charge, you're not going to be able to give Tyler a fair and impartial trial? I think we already got you. Okay. All right. If a police officer is a victim, is there anybody in here who's going to feel so much pressure to support law enforcement that you're not going to be fair, or you're going to start a police officer's testimony before they've ever said a word? You're gonna give it more credibility than you would somebody else. Is there anybody that would give a police officer, before having said anything, more credibility just because they're a police officer? Anybody? Okay. Is there anybody that's gonna feel, if a police officer is an alleged victim, you're gonna feel so much pressure to support them, you could not be fair?
All right, that's time.
If I could, may I approach, Judge?
Yes. All right, ladies and gentlemen, I talked to you about the ranges of punishment. Does everyone remember that?
Yes.
All right, and in these types of cases, you know, I told you the range of punishment. Sometimes it's 5 to 99 years or life in prison. Sometimes it's 15 to 99. Sometimes it's 2 to 10 years in prison. Sometimes it's 2 to 20. Sometimes it could potentially be probation. Does everyone understand?
Yes.
So what I need everyone, does everyone internalize that those are the ranges of punishments for this type of case? Does everyone internalize that?
Yes.
Now, if you were selected to be on this jury or any jury and someone were to be found guilty, you would hear perhaps evidence so that you can make a decision on what would be the appropriate punishment. Does everyone understand?
Yes.
So in some cases, you may sit and you may say, you know what, this is I've heard certain evidence. I think this person should be given probation. In some cases, you may say, I've heard evidence. I think this person should be given the minimum 2 years or probation. And in some cases, you may think that a person deserves more. Does everyone understand?
Yes.
But the key point is that you consider it. So when I tell you these are the ranges of punishment, then you need to consider it. It's not about giving someone anything. It's about, okay, I know that there's a possibility in this type of case that someone could receive probation if they were found guilty. Then you need to ask yourself, one, let me look at whatever the facts are that are given to me for punishment if you were to find somebody guilty. And maybe you would think probation would be appropriate. Maybe you would hear certain facts and you say probation is not appropriate. So then you would go to the next phase, the minimum, go all the way from the minimum all the way up to the full range. Is there anyone here who cannot consider the full range of punishment in this type of case? And I've told you what the full range of punishments are. All right, so that's 32. Thank you. And 17. Anyone else?
I agree.
All right, so here's the thing. Everybody raise your card if you cannot consider the full range punishment, and raise it now. All right, so that's 17, 28, 32, 43, 55, and 73. Thank you. Anyone else?
Can I ask you a question?
Yes.
So you're
What is your number?
51.
Yes.
You're talking about the range of punishment, because I'm not sure on that. I know like when juries come back with guilty or not guilty, it's an agreed upon decision. Is a range of punishment an agreed upon, or is that like an average?
No. You are not allowed to determine someone's punishment by lot or averages. That's not allowed to, that you're not allowed to do it. So you're not allowed to do that. For example, you're not allowed to say, you know what, let's just take this number, that number, let's divide it, or everyone, let's get out some straws. And we're going to cut the straws, and we're going to have somebody hold the straws, and then we're going to have somebody pull the straws. And long straw, this is what it is, or medium length straw, this is what it is. You're not allowed to do that.
So the punishment has to be agreed upon total by the jury.
Here's the thing. No, not necessarily. For example, the reason why I say if you're on a jury trial and you have to determine whether someone is guilty or not guilty, I always say if you can come to a decision. Because sometimes people say, you know what, 12 people can't agree. We can't come to a decision. And if 12 people can't agree, then 12 people can't agree. It's the same thing with punishment. Sometimes 12 people can come together and they can agree this person should get probation, or this person should get 2, or this person should get 20 or life, or whatever it may be. Sometimes they can't agree on punishment and they let the court know, you know what, we have 12 people, we can't agree on punishment. But in criminal cases, in Texas, not in other states, but in Texas, 12 people are on the jury, 12 people have to agree. And if they can't come to an agreement, then they let everybody know we can't come to an agreement. So your only choices when you're on a jury and you're deciding whether somebody is guilty or not guilty is, are they guilty, not guilty, or we can't make a decision. And it's the same thing with punishment. You know, full range of punishment, we can't come to a decision. You understand?
Yes.
Is there anyone else who doesn't understand? But you're not allowed to roll dice, pick by lots, or any of that in determining punishment if you were to find someone guilty. And that goes for any trial. You're not allowed to do that. Not by lot, not by chance, not by some system of averages. That is not the way our criminal system works. Does everyone understand?
Yes.
All right, so I'm gonna have you all step outside in the hallway. You are not excused for today. We'll bring you back in later to let you know who is gonna be on this jury. Everyone, please rise.
Your name, number behind, please. Don't take your numbers.
Oh, they're not up there.
I don't know. You know how hard it is to get to those not
It works. Good on.
The shops.
Those are all.
Yes, the trainings that are worth $5. I see them in some.
I am not marked out
Yeah.
anything. It's already my. That is.
Okay. Well, let's get that taken care of today. Well.
Oh, it's. Okay, so what's the difference?
Yes.
Oh, when I got hit. The difference.
Maybe we have a difference.
Either tomorrow or Thursday because this is available. All right. I had a number for you. Yeah, it's like, you have to never.
I was just so happy to receive that email that he has a place to stay. Thank you. All right, if there's anyone who's ready, let me know.
I have John De La Rosa, the trial case judge.
All right, so can you pull the file on De La Rosa?
That's not.
And where is your client? Yes.
Yeah.
All right, Mr. De La Rosa,
Yes, sir.
we're currently in a jury trial,
Yes, sir.
so we can't do two trials at once. The one time we did do that, but people were not very happy. Oh, Robert, he sounds like he wants to do it.
He's very enthusiastic.
All right, so you were late today. Don't be late again. You understand?
Yes, sir.
Because other judges will put you in jail. All right, so.
It was an accident, I'll just let you know.
Okay.
They're good. Just stop talking.
All right, this is what we're gonna do. They're currently in trial, so they can't really look at their docket to find out when a good trial date would
Let's go in
be.
order.
So when are you coming back for your other case? Was it towards the,
August 28th.
well, that's a little bit too late. Are you here the last week in July?
Yeah.
All right. Norma, can you set this for the last week of July? And this would be for you to get your jury trial date.
Okay, so there'll be a conferring date. Okay,
Yes.
perfect.
All right, Norma, what date?
So that we're not like.
All right.
Perfect for me, Judge. I'll be here.
So we're gonna bring you back on the 31st. Make sure you're on time. I'm gonna notate that you were not on time. And then on that date, it's not your jury trial date. That is the date for them to confer on an actual trial date for you. We have a lot of capital murders and murders coming up, so it may be pushed, but. Perfect.
Good thing on that time.
Okay. All right.
That's how I see it. I'll bring you this setting.
One more thing on it. I want this done before.
Oh, okay.
Thank you.
You're welcome.
First of all, how'd you start it?
Okay. Who's your client? All right. Let me see if it's been pulled. Oh, and Jason, if y'all want to do that in the jury room, you're more than welcome to go in the jury room. However y'all want to do it.
I mean, are y'all gonna agree to any of them?
Yes.
Okay, tell me the ones you agree to.
Okay, good on 12,
Okay.
17,
No, I'm just joking. I said,
28,
I'll go with those spots.
32,
Yeah. Good here.
Thank you.
I'll take Robert.
43,
Do a draft.
All right, let's go.
73.
April Pettis.
That's quite a few, y'all.
That would be fun.
There's more than that too.
Okay, y'all have more?
48, 49,
Okay.
57. That's it.
All right, we're
That's it.
currently in a jury trial, so therefore,
Let me know if you have.
Have your
Okay,
jury.
5 is beyond
Right.
reasonable doubt.
So I'm gonna give you a date
Also,
to come back, and that date
she
is
said that
going
she
to be
cannot give
for
the
us to
state
get a
official
joint
date.
trial date for you.
So agreed upon.
The persons who will be
Okay.
conferring with
Four
your attorney to
several
decide on an
things.
agreed upon jury date.
Was
They're the
that
people who are in jury. So,
one could not,
we can bring,
opinion of
can we
law
bring
enforcement,
this back late,
zero.
July?
or like bad, and then said they could not.
All right, so we'll
you know,
bring it
could
back
not
on
disregard
July
this bias,
31st on that
which
date.
is how they feel about Bear
You'll
County
get your
law
trial date.
enforcement. Also,
All right, once you sign the reset form.
another
you-
follow-up
you-
question. You have such a negative view of law enforcement that you cannot be fair. And that
You
was-
said what date, Norma? Thank you.
Okay, I'll bring it up with Judge. And then 6 is the same thing. She said, I mean, can you not disregard this bias? And she said, no.
I thought it was, you
Gonna
could,
try to
yeah,
get that
that's
ready.
what I'm quibbling on, but I just don't think any of those were actually.
Okay, all right. 15.
All right.
No problem. 15, cannot give the state a fair shake.
And Norma, for Robert Mauer's client, you said the 28th, correct?
The 31st.
All right.
Have that.
On Robert Mauer's client as well?
For 30.
All right, let me change
thing.
that.
Same for that one.
You're saying couldn't give the state a
Could I
fair shake?
Della
Right,
Rosa
that was-
back,
yeah.
please?
What was the,
Okay.
So no,
like, it was just like she would.
she said she would, it
would
it has a
tell
bias. Yeah, I mean, that's,
That's fine,
the
that's
question,
fine.
the question is like
Fine.
a few different ways.
Yeah,
So which one?
15 and 30. That's agreed.
Agreed, 15 and 30, okay.
What's left of that?
The, I guess I'll go down the list here. So 33, what I have for 33? 33. Oh, religious or moral reasons.
Same thing. Wow, that was weird because the judge asked that. and everyone said,
I mean, I don't care, but I mean, I'm just saying that the judge would probably, I mean, I don't care, but 33, because look, guys, these are for us and y'all, and
On.
No, I get-
so I just want to make sure you understand that. This is
Oh, I
not
have it.
34, then
All right,
I
let's start
have
with Prince.
for
Mr. Prince.
such a negative view, but you said you're not going to agree to that.
On this case, Your Honor, I was just
That
appointed
was
today.
34,
I haven't seen
37.
discovery. I did confer very briefly with the state before they had to start picking the jury trial. So I'd like to reset so I can. get
Yeah,
time.
religious morals, so y'all don't want
Right.
to. Okay, the 40,
Sir.
same thing, 45.
Norma, I need a 30-day date for discovery.
45 was the, such a negative thing, but y'all don't agree to that. And 59,
First week in August.
Yes.
I'm got a vacation notice out there, Judge, for that week. Could we do it maybe August 11th?
All right,
oh,
Mr.
59 was the guy. Y'all want?
Are you able to
59?
do it August 11th?
I'll
No.
keep 59.
All right, it's August
Monday
11th.
back
59.
after that.
I mean,
Right.
That's,
All
that
right.
No,
was for y'all.
right, that guy, dude. I remember that
It's,
guy.
it's,
Long
it's for
hands or
y'all.
no?
For y'all.
Yeah, yeah.
You're
So
in.
y'all want
Sure.
59?
No,
No,
I'm
I'm just
just
like,
yeah.
He has long things.
I like.
All righty.
Yeah, so I'm,
Oh, yeah, the guy with the beard.
Right.
yeah.
Well,
it's right
thank
here
you
in
so
front of y'all.
much
So,
for
like,
being on time. This is going to
okay,
be
so
your new
59 agreed
attorney.
to?
So
Okay,
make sure he has your
63.
contact information. They're going to give you a reset form, so you'll know when to be back, okay?
63 is a
Have any
negative.
questions about anything?
Outlook said
All right,
cannot
thank you.
disregard it. Said it on this one and this one,
Okay.
but y'all don't agree to
Just
that?
put it back into,
Pretty things.
Well, okay, this was the Bear County, you have to, such a low view of the law enforcement of Bear
He just
County.
rated him low.
Right, but then it was rated low here and then said,
It said,
not
can't- I
disregard,
can't
and then it
hold
has such a negative thing that I can't put it out.
that's.
Yes,
Okay,
Unless
so
you
y'all
have,
don't-
unless you have him for something.
but there's someone that's
Just
in
the
front of
posting
you.
thing, and then
Yes.
that's 60 or 74. Right
You'll need
here.
to have them pull the
That
file.
was for the fair shake.
All right,
Yeah, we're agreed.
Gilbert Salinas,
74. Okay, all right. So really, we're only gonna have to go up to 46 anyway. So, okay, all right, we're ready to approach from y'all are, okay? Y'all don't have, well, I'm sorry, y'all didn't have any other ones that y'all want? Did you? Probably covered-
You included a lot of ours
Yeah,
on there.
yeah, so I usually get them all. So, all right, guys, full close. Judge, we're ready when you are.
all right, Mr. Pelt,
Yes, Your
would you give me 5 minutes?
Yes, right. Mr. Simmons, have a seat again.
They don't know.
Yes, Your Honor.
Your client?
Yes, Mr. Salinas.
Court is calling. Are you,
Which ones are they for?
I'm sorry, what's your name, sir?
Gilbert Salinas, Judge.
All right. This is Zion.
Okay, I'm sorry. Check.
Cindy, are you ready? Everyone, please whisper. Court is calling 2024 CR 0127555. State versus Gilbert Salinas. Can I have parties announced?
Joseph Appelt for the defense.
And are you Mr. Salinas? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Salinas, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are proceeding with the lesser included.
Arson to a building belonging to another judge.
I'm sorry, arson of a building belonging what?
Belonging to another, I believe it's A-2 subsection 1 of the code 28. I can't remember the last two digits, Judge.
All right. Any objection?
No objections, Your Honor, no.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
Did you understand the state is proceeding on the lesser included offense of arson to a building belonging to another as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Salinas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of arson of a building belonging to another. There's a $2,000 fine. State recommends deferred adjudication. There should be restitution, if any, to the Henry B. Apartments. Did you understand that to be the plea? Defense?
That's correct, Judge.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
There are no such motions.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years, TAP evaluation, 200 hours of community service restitution, and no contact with the Henry B. Apartments. Did you understand? Those are recommendations from the state, and the court does not have to follow those recommendations. Then to the offenses, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
We'll talk about that. I'm taking responsibility.
I take it.
No.
You have to plead.
Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers states exhibit 1 and follows actions such as Your Honor.
No objections, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
With permission of the court, yes, Your Honor.
Anything you wish to say on behalf of your client?
If it pleases the court, Your Honor, I have personally known Mr. Salinas since 2011. He was previously a professional boxer, and I would represent to the court that the Gilbert Salinas I know and what is described in these records, what happened this day is an aberration and is completely out of character of this gentleman. I would also let the court know that since the arrest on this case, approximately a year ago, he has been supervised by the pretrial services where he's been on a GPS monitor. He has 0 violations. He's also participated in the form of an outpatient program with the Center for Healthcare Services, dealing with one of the issues of that day, which was he doesn't normally drink. However, he had consumed some Japanese liquors, is what I'm being told, which was brought over from Japan by his daughter that day, which unfortunately influenced him and made him act completely out of character. He has taken responsibility for this, Your Honor. He is a over-the-road, long-haul, independent truck driver. He's currently employed with a company called 381 Logistics out of Chicago. He does drive over the lower 48 states. He's out of town for about 4 to 6 weeks at a time. During that time, he has been on GPS tracking. He has had 0 violations whatsoever. We're asking that that be taken into consideration with respect to his probation, his deferred adjudication, community supervision as well.
All right. All right. Have you had any contact with the parties involved?
No.
I don't think we had.
Your Honor, they moved out of that apartment complex and have been out of that complex for almost this full year as well, Judge. And they live pretty much about 15 miles away now, is my understanding, but still within the same Bear County, but however, quite a ways from Henry B Apartments.
All right. Have you ever had any mental health diagnosis? Have you ever used drugs in the past? Do you have any children that are minors? Do you have any grandchildren that are minors? 8, what is the age? All right, this is what the court is gonna do. The court is gonna sentence you to 5 years deferred adjudication, regular reporting by Zoom or in person, no contact with the Henry B Apartments, restitution, if any, to the Henry B Apartments, Max G. Salinas, Edgar Ochoa, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, and the defendant is allowed to travel for work. And there's 200 hours of community service restitution. There's a $2,000 fine, and that will be probated. Field visits 1 time per month for 3 months. Probation, is there anything else?
Judge, allow for travel throughout the United States, right?
Yes.
And no contact, you want really fast.
Oh, no contact with the Henry B Apartments. Restitution, if any, to the Henry B Apartments, to Max G. Salinas, Edgar Ochoa, and there's to be no contact with Max G. Salinas or Edgar Ochoa.
If I may, Your Honor.
Yes.
Max Salinas is Mr. Salinas' adult son. Could we change that to no HOI, no harmful or injurious
Well,
contact?
if Mr. Salinas, Max Salinas, sends the court information that he has no objection to no harmful or injurious contact, I will do that.
Very well.
With
And
regards to the GPS, once parties have reached out to the complainants, I'll consider removal of GPS.
okay, in the meantime, it stays on.
Yes.
And with respect to the community service hours, at some time, since he is on the road quite a bit, would it be possible for him to purchase some of those out?
Yes,
Okay, and he would coordinate that with probation, correct? Judge?
yes. And probation, he's allowed to purchase hours, and I'll do that at $7.25 per hour. All right, is there anything else you need from the court? Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it? And sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, thank you.
Thank you, Judge. May I be excused?
Yes. State, did y'all make your agreements?
We're prepared for the time, Judge.
Oh, come forward. Mr. Navy?
They didn't, I don't know if they came up with any ones that they want to agree on. Sorry, Judge.
Oh, no problem.
We're ready. We'll give
Okay.
it to the court, but
Okay.
the coordinator.
Okay. Who have y'all agreed on in addition to?
Well, I don't think we've conferred on that.
We haven't conferred, I know that from the state point of view, we can agree to certain ones for time constraints, Judge. Because considering that this probably could go to about middle of next week possibly.
All right, so who do y'all agree with on time constraints?
The state agrees with 9.
And are you in agreement, defense?
No.
Okay, so 9.
Yes.
All right, so this is what I can tell everyone. Okay. So are there any agreements to time constraints or no?
I mean, do you have any time constraints that you're agreeing to?
11.
Okay, we agree to 11, Judge.
Yemi Reyes. All right, so have you had a chance to confer with the state?
We have.
All right, come forward. Ah,
Didn't have the interpreter here.
Interpreter just next.
oh, that's okay. So there are exceptions to rules.
We're just gonna ask for a reset.
All right,
It's just, I need to get,
all right, and has an
And
offer been
immigration.
tendered? Not
They-
very- Okay,
they tendered an offer today.
okay. Norma, immigration attorney is needed on that. Are you going to take care of that or you
Yeah,
want?
I'll take care of it. I'll submit it today.
Oh, does that mean that you want Mac to be the immigration?
Yes.
All right, Norma?
Yes.
If you can make sure that Mac is the immigration.
Yeah, I'll put it on there. You have the website, right?
Yes, I'm gonna do that.
All right, and could I have a 30-day reset, please? And you can put it as discovery.
Yes, sir. August 7th? Okay.
All right, August 7th.
This is great.
All right, it'll be August 7th.
Ahora me voy para agosto 7. Ahora me voy este día para agosto 7, este día. Y ya vas a hablar mejor de inmigración. Okay.
All right, thank you.
Thank you, Your Honor. Or big excuse.
Yes.
Yemi?
Juan Alberto Martinez.
Good afternoon, Your Honor.
Good afternoon.
You're having a lot of balls in the air today.
Yeah. So what is happening?
Judge State did have their file today. They are exploring my discovery request. And I believe we just need a little bit of time in order to be able to comply with it.
All right, Ms. Ferguson, can I have a 30-day reset for discovery on Martinez, please? All right, August 7th.
Thank
Do
you,
you have
Your
any
Honor.
questions, sir?
No, ma'am.
All right, thank you.
Good luck today, Judge.
All right, thank you. Zion Taylor. Is this an application?
It is. So, not needed production.
All right, court is calling 2024 CR 3860 State versus Zion Taylor. Can I have parties announced?
Duffy Petlife for the state of Texas, Your Honor.
Tommy Hernandez on behalf of Mr. Taylor.
And are you Mr. Taylor?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Taylor, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we are not. We are proceeding for the lesser included Class A misdemeanor assaults.
Any objection?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
The state is proceeding on the lesser included offense of Class A misdemeanor assault. That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to a $4,000 fine and 1 year in the Bexar County Jail?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Taylor, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
No.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of a Class A misdemeanor assault. There's a $500 fine. There's to be restitution, if any, to Joshua Norton, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 80 hours of community service restitution, and no contact with the complainant. Did you understand that to be recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State author states exhibit 1 and all attachments are.
We have no objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor, please.
Why are you doing this? This is silly. What, somebody, your friend, that was your friend, right?
No,
Not just someone I know of.
On social media?
No.
All right, well, well, what am I reading here? It says victim and suspect. I'm assuming he's SP1.
he is, Judge, and it may be a little bit off there. This had to do with the victims. The victim has a child with a woman that used to be his girlfriend and now an ex-girlfriend.
No, it says victim and suspect are acquaintances and social media friends.
They are not friends, Judge, or acquaintances. They only know each other through an ex-girlfriend and
On
child
social
that they
media?
had. No, so the social media, Judge, was when the victim was reaching out to Zion.
All right,
They're
so
not
today the
social
victim
media
messaged suspect via social media saying
Yes.
that his girlfriend was not faithful to him.
Instagram.
All right, so he goes on Instagram and says that your girlfriend's not faithful to you.
Yes, ma'am.
All right, so then you decide to go to his house for what purpose?
The whole reason why I went to his house was to get her from what happened with the police, from what happened over there. I was just gonna go pick her up because he took her phone, he called me, and he had her on the ground. She was crying. She called the police from another person, like 2 houses down.
That's not what it says in this police report. It says that he calls saying that your girlfriend is unfaithful. And I'm assuming this was his previous girlfriend?
Yes.
All right. So I don't understand why somebody picks up the phone and tells you your girlfriend is unfaithful. Your answer to that is, let me go over to their house. And if you think they're in distress, I don't understand why you won't call the police.
It's a little bit more involved, Judge. There's 2 separate locations. The police were called to the initial location. And
one of the witnesses, Kayla Gonzalez, who was his ex-girlfriend, and the complaining witness's baby mama, for less lack of a
Mother
better
of
term,
his
mother of her child. Yes, thank you, Judge. There was an incident that happened there, but the victim had already left. The police came to that location. They asked for, I'm sorry, Caitlin and Caitlin asked if the police would go with them to get her phone. They said no. So they relocated to the second location.
So they said
That's
no.
when everything happened over the.
So the
second
police
location.
said, no, we're not going with you to get your phone.
They said they didn't need to.
Okay, so they said, the police is like, yeah, I don't need to go with you to get your phone. So then your answer was, you know what? I'm going to go get the phone.
Yes.
That doesn't make sense to me. And I believe there's more going on because in the police report, it says that he told you that she was being unfaithful. How old are you?
I just turned 23 in February.
All right, so here's the thing, and this is a lesson that somebody should have told you and maybe you need to learn. You need to think before you act. And all of these people who think they're in these serious relationships and this is going to be the person I'm with for the rest of my life, sometimes it's not. Sometimes that's just a phase. To everything, there's a season. But what I will tell you is that if you would have ended up at the location where that person was doing this, and if they would have shot you, you know what would have ended up happening? People would have said, oh, he was over here causing trouble, talking about his girlfriend had been cheating on him. Your mom would have been on social media or Facebook doing a GoFundMe page for your funeral. And that person would, maybe charges would have been brought, maybe it would have been a jury trial, and they would have found him not guilty because they would have said it's self-defense because you were at their place. And then according to this, you go up to his place and you show up with other people. So there we go. And as a side note, did that hurt putting that piercing in your cheek, upper cheek?
No, ma'am. I prefer piercings over tattoos.
Oh, okay. All right. Are you employed?
Yes, ma'am.
What do you do?
I'm an HVAC tech.
And are you still with the girl in this?
No, ma'am. It's been over 2 years.
See, that's what I mean. Everything is a season.
Yes, ma'am.
And as a side note, do not get involved with other people who are bringing a lot of baggage.
Yes, ma'am.
Suitcases get heavy. Court is going to sentence you to 2 years deferred adjudication. There's a $500 fine that would be probated. Restitution, if any, and no contact with Joshua Norton. 80 hours of community service restitution. I'm going to order anger management. Once that's done, the community service hours will be deemed satisfied. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. Field visits 1 time per month for 3 months. And just 1 moment. All right, and what's the girl's name?
Caitlin Gonzalez.
Caitlin Gonzalez?
Yes, ma'am.
All right, and there's to be no contact with Caitlin Gonzalez. So if you decide to get back together, let her know you can't until your probation is over with. And that's CAITLYN.
Yes, ma'am.
Oh, I'm spelling it for probation purposes. And that's Gonzalez with an S. Probation, is there anything else? Is there anything else? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed this plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you. Make better choices. All right, thank you.
Maybe excuse me.
Yes.
Thank you.
Howie. All right, did you get the email?
I did.
I'm like, yes. So we're gonna call you back on Thursday. They say that they have accepted you into the program, but they need to get a lower bunk. So we'll bring you back on Thursday and Norma will see if we can get the AGs here by Zoom.
Wonderful.
Okay.
You're good, Mom. Thank you, Honorable Judge.
Oh.
Stephanie Boyd, Miss Hollywood.
You're so welcome. I really appreciate that. I'm so glad we were able to get that done. It took an act of Congress, though.
Good for you. I greatly appreciate your concern and you stepping in. You got them hopping over there at the jail too. The medical came right away and had me sign. You know, I was.
All right.
Thank you.
All right, you're
God
welcome.
bless you.
Oh, thank you. God bless you too.
See, Mr. Howie. Thank you.
Louis, you have one. Yes. Okay, just making sure I didn't.
Desiree Castro,
Yes, sir.
that you?
Yes.
All right, so on this one, Norma,
Yes,
can we recall this at the end of the month for you all to get your jury trial setting? We can't have a jury trial. We're currently in trial on another case.
July 30th.
And that would just be for you to get a date.
Okay, thank you.
All right, thank you. La Prentice County. Good afternoon. How's it going?
Doing fine. There's two matters. One is even before you go on the record, one is a termination of probation. The probation officer is gonna need some time to get some information from their officers, so we're just asking that we can reset that.
All right, when do you want to recall it?
We can do it. She said she only need about a week, maybe a week or 10 days, whatever is at the convenience of the court.
All right, Ms. Ferguson, can I have a reset date for 10 days?
I can use July 10th.
That's fine.
July 17th?
That's fine.
All right, we'll bring you back on July 17th.
Yeah, there was another motion, Judge, motion for return of property. You had a case out of this court where the case was dismissed.
The state is in agreement with
In
it.
agreement,
so
Judge.
I will sign it.
Thank you, Judge. We appreciate it.
You're welcome. And if you will, if you need a copy of it, which I think you do. And that was in 3 different cases?
That's correct.
All right, state,
Yes, Judge.
that's the return of property in all 3 cases?
The motion that the state saw was specific to the impersonate public servant.
It's all the same property and
All right, if y'all will look this over and if y'all are in agreement to all of the cases, then I will sign it. And if you'll put agreed on there for me, please. Who's here on Robert Castillo? Yes.
We're on the trial docket today, Judge.
I'm sorry?
We're on the trial docket today.
Yes, so what I'm gonna do is I'm gonna recall you for the end of the month. We're currently in a jury trial, so I can't do 2 trials at the same time. Ms. Ferguson, when do you want to recall this?
July 31st.
And on that date, counsel, it will be for you to get a jury trial date.
Okay, Judge. I'll put them on here right now.
All right, thank you.
Thank you, Your Honor. Appreciate you.
You're welcome. William Jones. Anyone else? If you have not been called, it's because I don't have your paperwork. Let me know when they turn in the paperwork.
I'm doing the search right now.
All right, thank you. Court is calling. Court is calling 2024 CR 2651, State versus William Joseph Jones. Could I have parties announced?
Stephen Pitlock for the state of Texas.
Tony Hernandez, by half Mr. Jones.
And are you Mr. Jones?
Yes, ma'am, I am.
Counsel, have you received all discovery? And did you review it with
Yes,
your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Jones, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, miss.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we are not. We will be proceeding with count one, but we are waiving and abandoning the enhancement allegation.
Any objection?
No, Your Honor.
Mr. Jones, did you review the court admonishments and defendant's waivers and affidavit of admonitions with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. The state recommends community supervision. There is no application for deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor, with
Yeah.
one stipulation.
Yes.
We would like to ask the court appropriate time to probate part of its fund.
Okay. All right. Other than that, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Into the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea.
State offers states exhibit 1 and all attachments, Your Honor.
We have no objections, Your Honor.
All right, state, you may excuse.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Jones is indigent at this time. He's been in jail for over 30 days. He does odd jobs and yards, landscape, that type of situation. We would ask the court to probate a portion of his fine. He also had a recent death in the family, Judge, so that's cost him some time away from home and from work, and of course, just being in jail.
All right, how often were you using?
Every day.
Okay. Do you have any children?
No, I don't. My wife does.
And what are their ages?
They're all out of the house. All of them are out of the house.
Are there any minors in the home?
No, no.
When's the last time you had full-time employment?
Full time,
Mhm.
about a year ago.
All right.
I've been doing this, I'm trying to get my own business going.
Okay.
Doing lawns and trim tree and stuff.
All right, this is what the court is going to do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's a $2,000 fine that will be probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors, regular reporting by Zoom or in person, regular random UAs, TAP evaluation and a referral to felony drug court in custody, 200 hours of community service restitution. I'm going to order the MRT. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. And there's to be no residing with minors. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
Judge, for clarification, is the court sending him to felony drug court?
He's going to do a referral to felony drug court, and that's going to be done in custody. They'll probably be able to see you hopefully before this week is out. If not, they'll probably see you at the beginning of next week.
Okay. And depending upon that, it'll be when I'm.
Oh, then you will be transferred to felony drug court if they accept you. That's a very good program. So I'm hoping that you get accepted into that program, because if you were using every day, you have a pretty bad habit, and felony drug court will be able to take care of that, okay?
I think his question, Judge, is will it, once, if he is accepted, does he get released at that point?
He will be transferred to felony drug court, and they'll make a decision on that.
Okay.
Because they'll be in charge of his treatment. They may say that he needs inpatient treatment. I don't know. If they say that he needs inpatient treatment, then they're going to give you inpatient treatment. Okay? All right. Thank you.
Thank you, Judge. Maybe excuse.
Yes. Christina Garcia.
Ms. Jones.
All right. We're going to go back on the record. Cindy. Oh, all right. We're back on the record in 2023 CR 10004 State versus Tyler Ashbaugh. Right.
She's with them. Yeah. She lives here, but she works.
All right, how many witnesses do y'all have? Okay,
3 to 4, Judge.
all right. So state, who's your first witness going to be? All right.
And Deputy, Makia, we'll stop at 5 so we can make sure that he gets taken back.
Yes.
And to the parties,
If there are any witnesses who can be by Zoom, because they're gonna have to take this back by 5. Okay. All right, so if you need them by Zoom, because we may not get finished today, that's what I'm saying. All right, the court is calling 2024 CR 00693. Okay. Oh, that's okay. I can't look over the computer system. Thank you. I'm sorry, Cindy, I can't see over the screen. The court is calling 2024 CR 00693 State versus Alexander Rodriguez. Can I have parties announce?
And Nancy Jones for the state of Texas.
Marissa Fernandez Pratt and Marissa Giovanni.
All right, and are both parties ready to proceed with sentencing?
Yes, sir.
All right. State, you may call your first witness. All right, you've previously been sworn in. You're still under oath. All right, state, you may proceed.
Can you hear me okay? Now, can you please just tell the court how this acts? I can really hear what you're saying.
Yes.
But that's the microphone's not on, Judge. The microphone's not on.
Oh, it should be on.
Grab that microphone, please.
Thank you. All right, thank you. All right, you're still under oath. All right, state, you may proceed.
Can you move the mic towards you, Rick, please? Thank you.
He was the first veteran of the and he betrayed my trust, and he was supposed to protect me, and he didn't. He made it hard for me to open up to people like my family, in relationships. And for so long, I felt so guilty that it was my fault. But I was a child, and he took that innocence from me, and from my childhood. And
Has this affected your family life in any way?
yes,
In what ways?
and I feel like I can't trust people as much. And I feel like my stepfather gets the most of that. I feel like I'm mean to him sometimes, and I don't mean it.
Has this affected your relationship with your friends at all?
No, I'm just even.
Has this affected you in relationships with other boys?
Yes, it's hard to trust them.
One last question, Emily. Is there anything else you'd like the court to know about how this has been an impact on your life? That's the witness, Sean.
Any questions?
Yes. Can you hear me? Yes. Emily, as you recall, you testified in trial, the guilt innocence phase, that you couldn't remember if there was penetration. Do you recall that? Yes. Okay. And you said that this individual, your dad, is supposed to protect you and that he took your innocence from you. Where did you learn those phrases? I'm sorry, I don't understand what I learned. Did you come up with those phrases yourself, or did someone repeat those to you? No. Those were your phrases? Yes. Okay. How many, you finished therapy within a year or less than a year, I believe, is that right? Yes. And this was in 2022? I think I don't know what year. Okay. And so you haven't gone back to therapy at all with any of these issues that you've had, right? No. And then you also went to school and everyone thinks was unanimous that your schoolwork was not affected, correct? No. And then you said that you cannot trust others, but you shortly after this allegations came out, you still continue to message your father and his fiance. Yes. And then you said it was hard to trust boys, but that didn't stop you from speaking out of the home. The speaking out of the home, right? No, that's from. Right, but that didn't stop you from trusting that one. And you said that you get mad at your stepfather, and you don't mean it. And could that have anything to do with the fact that he abused you and your brothers?
You're saying speculation.
Overruled.
You said no? No. But you do agree that he has been found to have been physically abusive of you and your brothers?
Objection on speculation, hearsay.
Overruled.
A long time ago. Okay, and you would agree that he has been physical with your mom in your presence?
Objection on irrelevance.
Overruled.
Has anyone made you testify here today about what would happen to your dad? What was that? Has anyone made you say the things that you're saying here today? No. Have you gone over the testimony with your mom? No. And have you gone over the testimony with the prosecutors? No. Do you recall in trial being told and instructed not to speak about the case during the breaks? Yes. Do you recall testifying in trial that you did?
Objection to relevance.
Overruled.
That you did speak to your mom about the case and about your testimonies?
Objection to relevance.
Overruled.
Yes. Maybe yes, or do you remember testifying to that? I think I did. Do you recall visiting your dad when he was serving time in prison? Yes. And who took you to that? I can't hear you. And that's your dad's mom. And did your mom take you to see your dad?
State.
Still a question, Your Honor. And we didn't hate your father? You still love him? And how does that make you feel after what he did to you? No further questions.
Nothing further to answer.
All right, is the witness excused?
Yes. Yeah.
All right, you may step down. All right, state, call your next witness.
State House Clarissa Herrera.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Clarissa Herrera.
All right, state, you may proceed.
Good afternoon. Tell us how you have seen your daughter be affected by what this defendant did to her.
It affected her in every way, her interactions with her family, with her friends, any kind of relationships that she has ever formed has impacted her in every way.
Talk about family. How has your relationship been affected by this, your and your daughter's relationship?
It's definitely put a strain on the relationship. I really tried to be there for her emotionally. And just as much time as she needs, I try to be there for her.
What about with other family members?
I know that she's very distant. They try to reach out to her frequently, and she You got a clear shot, that's nice.
Was she always like that?
Very brief, yes.
And what about, what have you seen? Or how have you seen her relationship with her friends?
I know her long-term boyfriend currently, he just been with for 2 years. It took a really long time to get good close to people. Very angry. Has a lot of rage inside of me.
Why is that?
Because I don't understand how somebody can do that to their own child. Somebody that is their me. I can't comprehend that. How can you father someone and then betray them that way? Disgusting.
Is there anything else that you would like to know about how this has affected you or your family? Okay, we'll pass with this, Sharon.
All right, defense.
You testified previously that you didn't know any difference, you saw no differences in Emily's personality that would indicate she had been abused, right?
Right, that's correct.
So when you testified to that, were you telling the truth then, or?
Yes, so
Wait, let me ask you this. Are you saying you were telling the truth?
yes,
Okay. But now you're testifying and saying that she has been completely impacted by this case and has ruined relationships, right?
Yeah.
Okay. Even though you had testified previously, that when you didn't notice anything was wrong, you obviously there were no signs.
I guess it was an eye opener because I found out what happened. Now looking at it from the outside perspective,
Let me ask you here, when she got her period, did you or did you not tell her that after if somebody had sexually assaulted her? You never said that. No. Would it surprise you to know that Emily testified to that?
Yes.
In trial, you were instructed to not speak to Emily about your testimony. You call that instruction. And you in fact did speak to Emily about her testimony, correct?
I wanted to check on her mental well-being.
Okay, so the answer is yes, is that right?
I checked on her mental well-being, yes.
Okay, so you disobeyed the court order by speaking to a witness who is under the rule.
I just asked her if she was okay, if she needed anything.
Okay, so you didn't talk to her about her testimony?
No, I didn't listen to have any interaction with that conversation with her.
So you did your best not to. So the question is, did you in fact talk to her about her testimony and how it went?
I don't know if checking on her mental well-being. Are you okay? How are you? How can I help you? If that counts as talking about the case.
Okay, so did you ask her, what did you testify to?
No.
Did you ask her about what her testimony would have been or will be?
Overrule.
If anything, I've never even asked for details about what's happened to her. Doesn't know.
Okay. And so let's go back here. You said that she had a long-term boyfriend of 2 years?
Yeah, for the 17 months.
Okay, and you testimony is that this has impacted your relationship?
Yes.
And you said you're very angry and those are your words, right?
Yes.
And approach judge.
Yes.
recall sending, defense exhibit 1. Text message between Alex and yourself.
Yes.
Okay. And, is that the message you sent to them?
Yes.
Okay, has it been altered or amended in any way?
No.
Is it fairly and accurately depict the conversation between the two of you or the three of you?
Yes.
I move to admit defendant's exhibit 1.
Statement object based on hearsay, it's not a this court statement used.
All right, could I see defense exhibit number 1? And we should probably label it defense P1, so the record will know that it's for the punishment. Okay. All right, defense exhibit number 1 for punishment, and it's labeled as defense P1 will be admitted. Thank you.
With regard to what you said, when you said you were rageful, is that what you meant? You were pretty upset that you were no longer going to be getting health support payments?
I've stated before that I've always felt it was a big obligation to prevent anything.
So the question is, were you upset that they were no longer going to provide health support?
Whether it's that we couldn't pay,
Correct, he was in custody, right?
we didn't use the custody, so, again, I've always felt like it was a financial obligation to prevent anything.
You did not know that he was in custody when you sent that message.
You did not know me.
Have you always had this like rageful or angry persona? Did you poison your teacher when you were younger?
Yeah.
Overall,
So you poisoned your teacher when you were younger and you got,
Children's and 6 and 9.
all right, that'll be overruled.
were you expelled?
It's something that we do.
But you were sent to juvie, isn't that right? No. You have probation?
Probably community service.
And then you recall what Mr. Rodriguez was in, he went to prison for, right?
Yes, he burned down a house and killed animals.
Do you recall telling him to do it?
No, he did try to escape, but I was with him. Thankfully, I was not.
Did you and your mom take him to school right after he burned down the house?
No, before.
You took him to school before.
We were at, I was helping out my little sister. I was pregnant. We came home and the entire road was closed off. Ambulance, fire truck, everything. We had to walk to our house.
Okay.
Yes.
You had contact with an investigator from CPS December 12th of 2008, and you told them that you felt bad, that you told him to burn down the house, correct?
Objection to hearsay, Your Honor, and relevance.
Overruled.
Where is this?
You can go and read it. You can go practice your movie.
I'm sorry, what was your question?
You recall telling CPS workers, investigators, that you felt bad because you told him to burn down the house.
You never told him to burn down the house.
And my question was, did you tell CPS that?
No, I don't even see that here.
Okay.
I see that I talked about a relationship. That's pretty much it.
One second, one. Yeah. Do you recall writing letters to Alex while he was in custody?
I believe so for a short period of time, yes.
Well, there were a lot of letters, right?
More than likely, but I'm not sure how many.
Yeah.
You're saying that he was in prison?
When he was in prison, you would write to him pretty frequently, right?
I believe so.
And you weren't afraid of him if you were writing him in prison, telling him that you missed his butt, that you loved him, right?
I don't know. It's a lot.
You testified that there was domestic violence in your household, right?
Objection to relevance, Your Honor, this doesn't.
Right, what is the relevancy?
I want to know why she didn't get her help sooner.
All right. All right, that'll be, and when you say get help sooner, what help are you speaking of?
You did help.
All right, you can ask the question. The objection is overruled.
When, so you testified that there was domestic violence in the house, correct?
I don't think so.
You don't believe so?
That I see that there was domestic violence.
Correct. Do you recall being asked about it and you testifying that you were over dramatic in your younger years?
I'm sorry, I'm sure.
Do you recall testifying that you told Alex that there was domestic violence in the household?
I would always state when there was this argument, or that the apartment, there was domestic violence.
You never told him that he's hitting you, that your current husband was hitting you?
I think I would state all the arguments, or any argument that we would have.
And you didn't testify in trial that because of that, you felt like you were being over dramatic?
Yes, I did feel like I was being overdramatic.
And then, you said you had a terrible relationship with your mother,
Yes,
and would you agree that your history, your CPS history starts from a very, very young age?
Objection to relevance again.
All right, what is the relevancy?
I'll rephrase.
All right, the objection is sustained.
Did you talk to your daughter about making up these charges so that you would get a leg up?
I understand the question.
Did you force Emily to come out and make these allegations against Alex?
No,
Because he was getting married to his fiance.
no,
Do you recall that you blamed Alex for the fire because, I'm sorry, that you blamed yourself for the fire because you had accused Alex of being in a relationship with that girl?
Objection to relevance, or say.
Relevancy?
To the punishment evidence?
No, I mean, how is this relevant to the punishment of this case as it relates to your client?
Well, because, well, my client will testify, and I guess I don't have to release her, I suppose. It will become relevant later, but
All right, then the objection to relevancy will be sustained.
past evidence.
All right, any further questions?
State, Your Honor.
All right, defense, is this witness excused or you want them available? All right, you need to make sure that you're available if the defense wishes to recall you. Thank you.
thank you.
All right, state any other witnesses?
Our conviction of this defendant, and also reintroduce into evidence all evidence admitted during the trial in this case. Guilt and innocence phase of the trial.
All right, state's exhibit number 1, the judgment, and is this state's exhibits P1?
Yes.
Okay. No problem.
And we maintain any objections to that we had in the, not, guilty case.
All right,
If we had objections. No, they didn't.
okay. All right. The court will note the defense's objections and all prior rulings as they relates to the evidence that was submitted in the first phase of the trial. And as previously stated, the court is accepting into evidence state's exhibit P1 without objection. Yes. All right, any other witnesses? All right. All right. So, are you able to have your witnesses on another date? Or either by Zoom? All right, and I'm sorry for the late start, everyone, but we had jury selection in a lot of cases that were happening. So if you all are not able to be in person, you can be by Zoom. And if you all would discuss with Ms. Ferguson, she'll tell you what time you all can come back either tomorrow or Friday.